All right, everyone, welcome back from lunch. I am pleased to introduce the participants in panel number 3, Looking Forward, Criminal Justice Policy and Reform. First, I will introduce our distinguished moderator, Judge Ketanji Brown Jackson, who received her commission as United States District Court Judge in March of 2013 after her nomination by President Barack Obama and confirmation by the Senate. Until December of 2014, she also served as Vice Chair of the United States Sentencing Commission under Chair Patty B. Saris, who we heard from yesterday. Judge Jackson previously focused on appellate litigation as of counsel at Morrison and Forster, right across the street here, and handled criminal appeals as an assistant federal public defender in Washington, D.C. She clerked for 3 federal judges, including Judge Patty Saris, now Chief Judge Patty Saris on the U.S. District Court for the District of Massachusetts, Judge Bruce Selya on the U.S. Court of Appeals for the First Circuit, and Associate Justice Stephen Breyer of the United States Supreme Court. Judge Jackson is currently a member of the Board of Overseers of Harvard University, and she serves on the Governing Council of the American Law Institute. She also currently serves on the board of the D.C. Circuit Historical Society, and as I always embarrass her when I introduce her, she also has the distinct honor of having seen my halting courtship efforts because she was my wife's college roommate. And so, yeah. So yes, lots of information she has for you. Next, I'd like to introduce Ed Chung, who is the Vice President for Criminal Justice Reform at the Center for American Progress. Previously, he served as Senior Advisor on Criminal Justice, Policing, and Civil Rights issues for the Assistant Attorney General of the Office of Justice Programs at the U.S. Department of Justice. And Carol Mason, who had that role, is now president of John Jay College of Criminal Justice in New York City. Mr. Chung also held positions in the Justice Department Civil Rights Division, including special counsel to the Assistant Attorney General and federal prosecutor with the criminal section of the Civil Rights Division, where he received the John Marshall Award for successfully prosecuting the first case under the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009. Mr. Chung's experience has also included serving as senior policy advisor at the White House Domestic Policy Council, counsel to Senator Patrick Leahy in the U.S. Senate Committee on the Judiciary, and as an ADA, an assistant district attorney in the New York County District Attorney's Office in Manhattan. To his right, we have Todd Cox, who is the Director of Policy at the NAACP Legal Defense and Educational Fund. Mr. Cox began his career as an honors trial attorney with the Civil Rights Division at the U.S. Department of Justice. He then spent time as a civil rights litigator and policy advocate, serving in leadership positions at the D.C. Public Defender Service, the NAACP Legal Defense Fund, and the Lawyers Committee for Civil Rights under law. He served in the administration of President Obama as the director of the Office of Communications and Legislative Affairs at the United States Equal Employment Opportunity Commission, and then became director of criminal justice policy at the Center for American Progress, where he led a cross-programmatic team addressing a range of criminal justice policy issues before returning to LDF. To his right is Brandon Garrett, who is the White Burkett Miller Professor of Law and Public Affairs at the, and the Justice Thurgood Marshall Distinguished Professor of Law at the UVA School of Law. His research and teaching interests include criminal procedure, wrongful convictions, habeas corpus, corporate crime, scientific evidence, civil rights, civil procedure, and constitutional law. His recent research includes studies of DNA exonerations and organizational prosecutions. He clerked for the Honorable Pierre Laval of the U.S. Court of Appeals for the Second Circuit, and then he worked as an associate at Neufeld, Scheck, and in Bruston in New York City. And he's the author of numerous books, and his work's been widely cited by courts, including the United States Supreme Court and courts in other countries, such as the Supreme Courts of Canada and Israel. To his right is Paul Marcus, and Paul Marcus is the Haynes Professor of Law at the College of William and Mary. And formerly the Law Dean at the University of Arizona Law School, his teaching and research interests are in the criminal justice, comparative law, and intellectual property areas. Prior to going into teaching, Professor Marcus clerked on the U.S. Court of Appeals for the District of Columbia Circuit and practiced law in Los Angeles. He's the author of several books and numerous articles in the criminal justice area, and he serves as a consultant in ongoing criminal prosecutions on a regular basis. He was elected by the full 180 United States Law School membership to be president of the Association of American Law Schools, following in the footsteps of our dean, Blake Moran, who served in that role 2 years ago, and is the recipient of numerous teaching awards, including the College of William and Mary McLaughlin Teaching Award for Classroom Excellence. And then last but not least, to his right is Nkechi Taifa, who is Advocacy Director for Criminal Justice at the Open Society Foundations. Her areas of expertise include federal sentencing reform, law enforcement accountability, prison reform, reentry, racial justice, and executive clemency. She's also the founder of Justice Roundtable, a group that I belong to, an advocacy coalition advancing federal justice reforms, which was instrumental in the passage of the 2008 Second Chance Reentry legislation and the 2010 Fair Sentencing Act. She served 7 years as founding director of the Equal Justice Program at the Howard University School of Law and as an adjunct professor at both Howard and at American University Washington College of Law. She was a legislative counsel for the ACLU, public policy counsel for the Women's Legal Defense Fund, and a staff attorney for the National Prison Project. She's received numerous awards for her social justice advocacy and accomplishments, and as a private practitioner, she represented indigent adults and juveniles and practiced employment discrimination law. And she is a graduate of the George Washington University Law School, so I'll mention that. And with that, I'll ask you to join me in a round of applause for our panel.
Good afternoon to you all. Dean Fairfax has already done the heavy lifting of giving you the information about our panelists, their distinguished and impressive bios. And I think the only real function of a good moderator is to keep the trains running on time. So I will start by turning to Mr. Chung. I think each of our panelists will come to the podium to give their presentations.
Thank you, Judge. I'm really nervous right now. This feels like an actual courtroom. And this is the closest that I've ever gotten to anything related to law review. So thank you to GW for inviting me here. I have the benefit of not being a scholar, so I'm lowering expectations immediately. And I am also relying on a PowerPoint as a crutch. I just want you all to know that. So this issue, for me, the topic of this session, the future of criminal justice reform, is something that I've been thinking about during my time here at the Center for American Progress. I've been here less than a year, but it's just been really salient, especially in the last couple weeks. The Center for American Progress has, I was just joking with Nkechi that we're professional conference goers. And we had 2 conferences in the month of October, one earlier this week on our Clean Slate initiative that talks about automatic sealing of certain records after a set period of time. And then 2 weeks before that, and this is probably a social faux pas, but I'm gonna do a little plug here. We had a Smart on Crime conference in New York City with my former boss, Carol Mason. And we brought together people from all across the country talking about the innovations that they're doing that are making our criminal justice system more fair, more just, using comprehensive approaches and data-driven solutions. And some of the conversations that we had there centered around this issue: what is the future of criminal justice reform? And there was a lot of frustration, to be honest with you. And there was a lot of just angst, because people have been working on this topic and on this subject for decades. And I literally was talking to somebody earlier this week who banged his head on the table in frustration at the incremental approach that we're taking for criminal justice reform, And the fact that any reform that we put in, sustainability is like that elusive goal out there that can change with the change of an election, change of an administration, or just change in leadership. And so that kind of frustration is something that I'm feeling, that I know many people in this world are feeling. And the question is, what is not only the solution to that, but what are the reasons for it? And I think some of my fellow panelists may be talking about some of the important issues such as systemic racism and the fact that probably half or more of the country don't even acknowledge systemic racism. The fact that these problems have taken place or have accumulated over decades with billions of dollars behind it, and it'll take decades, hopefully not decades, but at least some time and billions of dollars to fix it. And also the issue of culture, the fact that we can't wean ourselves off of tough on crime rhetoric and policies. But for me, the one thing that I want to focus on is the fact that the criminal justice system is huge. Absolutely huge. And it's not a system. It is, as you know, a conglomeration of systems that begins with the police. And for me, the police is, as many of you have heard, the face of the criminal justice system, the face of government. And if you have a good police chief, that's a great thing. You can make a lot of change. I see my friend Tracy Mears in the audience. She's been working with many police chiefs and instituting a lot of change. But Tracy would be the first one to tell you that a police chief answers to a mayor. And a police chief and a mayor may initially be on the same page, but later on, a police chief and a mayor may not see eye to eye. And so if those two aren't on the same page, that's problematic. But then after your arrest, you usually go to jail, or a lot of times you go to jail, and the jails are run by sheriffs who are independently elected, just like a mayor is. And a sheriff can have all the reforms they want, but if the sheriff is not aligned with a mayor and a police chief, criminal justice reform falters. And then after the case goes to jail, or after the defendant goes to jail, then they come before a prosecutor. That was my. I searched Google for icon of prosecutor, and that's what came up. So we went like old English prosecutor, barristers here. And prosecutors are independently elected county prosecutors. So you already have 3 independently elected entities, and then a police chief who is a powerful voice in the criminal justice system. And we've only gotten to the point of charging. And then after that, the case goes to a judge, and not federal district court judges, but state judges are often elected. So you have 4 independently elected entities and 5 powerful agencies, if you will, or components of the system. Then after that, if you're convicted and the judge, let's say the judge sentences to a state prison sentence, then you go to a state prison facility, and that is run by the head of the State Department of Corrections. That is responsible, I'm from the state of Ohio, to the governor, that is accountable to the governor of that state, or who appoints. So you have now 5 independently elected people, entities, in charge of 7 very powerful criminal justice agencies. And all of this is governed by state laws when we're talking about dozens, if not hundreds, of state legislators who weigh in on criminal justice. So criminal justice reform is hard because we are reforming multi-systems and we're keeping accountable different actors that each have independence from each other, and that change in one part of the system does not necessarily flow to changes in other parts of the system as well. So in answering, or in kind of coming to a point for this session, instead of leaving you with doom and gloom, I was trying to figure out what to focus on. And I'm in the process of hiring some people for our team here at CAP. And one of the questions that I'm asking, and hopefully nobody here has applied because you're going to get a leg up on the answer here, is that if you were to pick one of these areas or one area of the criminal justice system to focus on, what would that be? And my answer to this and the future of criminal justice reform is policing. Because policing, as we all know, controls the front end of the system. And for me, as not a scholar, but as a practitioner and as somebody who's involved in policy, turning off that spigot from the front is what is crucial to making radical change in the criminal justice system. The problem that we have in policing today, though, is that we have a lot of progressive police chiefs, but the composition of the police department is what is the problem. And I'm not talking about the fact that police officers are the problem. I am somebody in the criminal justice reform movement who supports police and who supports good policing and who supports the profession of policing. I'm talking about the fact that we need criminal justice reformers as police officers. We need police officers who are progressive and small p progressive in their approach to their profession. And you may have covered this before, but this is incredibly consistent with what we're talking about here in terms of the 50th anniversary of the Johnson Commission, that we want higher levels of knowledge, expertise. I'm going to call it, we need police officers who are smart on crime and who believe in smart on crime principles. We're not only talking about gender and racial diversity, we're talking about the fact that 20-year careers create sustainability in criminal justice. And an entirely different perspective of what it means to be a police officer has the most trickle-down effect in the criminal justice system than anything else that I can think of. So, we have an opportunity now, because there's been news story after news story this year that police departments are facing crucial shortages of police officers for multiple reasons. But if you look at this story by NBC News, you'll see in there that we're not only talking about diminishing pay and high risk, but of a recent bad rap. And out of dysfunction, out of conflict creates opportunity, and this is what I think we have an opportunity to do. Because it's not only about the fact that standards are changing and people are trying to lower standards and so forth. My hope is that we can expand who we're recruiting, and that we're recruiting a higher level, a more justice-minded police officer to take these positions. So I am literally going to take the role of a police recruiter right here. And so please take this to any of your colleagues and friends who are looking for jobs. I'm sure every friend of yours is employed, I know. But if they are not, I encourage you strongly to consider policing as a progressive profession. And I am going to list, I'm going to do this P, all of these like P words that are coming here. Policing is a progressive profession because you're a problem solver. You are a problem solver. It is a thinking person's profession. And we need people who are able to take in facts, quickly synthesize them, and come up with a solution to them. You are the ultimate public servant. By the way, we should record this actually and just like take it to police departments, and you all should join me in endorsing this. You are a public servant. You are a people person because you are interacting with people all the time. And you are part of one of the largest public unions in the country. And I only say that half facetiously because if you think that police unions are a barrier to criminal justice reform, the only way that those things are going to be changed is if the membership changes and if the membership changes the leadership. I think policing is the future of criminal justice reform. If there was one area that we can focus all of our energies on and make a change, I think it's policing. Thank you.
All right, next with Mr. Cox.
Thank you, Your Honor. And just to echo Ed, it's been about 10 years since I've actually presided or been a participant in anything presided over by a judge. So I'm a little unsteady. Good afternoon, and thank you for this opportunity to participate in this important conversation regarding criminal justice reform. This afternoon, I'd like to discuss from our perspective, LDS perspective, why we need criminal justice reform and why that reform needs to be comprehensive. I'd like to also address some of the backlash that we think we're experiencing, particularly from this particular administration, and then give some thoughts on navigating the criminal justice policy issues going forward. For decades, LDF has worked at the federal level and at state levels to advance policies that would eliminate racial bias at every stage of the criminal justice system, from arrest to reentry. So my examination is going to be through a racial justice lens. Many of you know the numbers, know the statistics, but I'm going to read them anyway. In recent decades, the number of Americans who have some sort of criminal record has grown significantly. Incarceration rates in the U.S. have more than tripled since the 1980s. As a result of this increase, the U.S. currently constitutes approximately only 5% of the world's population, but holds 25% of the world's prison population. And this rapid increase is largely attributable to the increased incarceration of nonviolent drug offenders over the last 3 decades. From 1975 to 2005, the U.S. incarceration rate has increased by 342%. Criminal justice policies that led to this incarceration rate surge continue to drive racial inequality and poverty. If not for mass incarceration, one study has shown that from 1984 to 2000, the poverty rate would have dropped 20%. And we know that the consequences for having a criminal record are significant. It can lead to barriers to employment, housing, and other kinds of social interactions. And the impact of the criminal justice system and the impacts I described disproportionately impact communities of color. People of color are disproportionately represented in our prison system as they represent more than 60% of the prison population, but make up 37.9% of the U.S. population. African Americans, Latinos are particularly impacted. African Americans make up less than 13% of the U.S. population, but are 40% of the prison population. And the prevalence of arrest rates and criminal convictions are far higher among African Americans and Latinos than for whites. African Americans are 2.5% times more likely to be arrested than whites. And these racial disparities are not simply explained by disproportionate rates of criminal activity. One study found that in 2005, African Americans represented 14% of current drug users, yet they constituted 33.9% of persons arrested for drug offenses. So rather, all of this demonstrates something systemically wrong with our system, and that the roles of racial profiling and discriminatory criminal justice policies have played and continue to play in our criminal justice system. And all of this has some very important civil rights and racial justice implications. A 2004 study by Professor Deval Pager found that the white job applicants with a criminal record were called back for interviews more often than equally qualified Black applicants who did not have a criminal record. According to Professor Pager, the criminal justice system plays a central role in sorting and stratifying labor market opportunities for those with criminal records. Employment policies and practices that apply a blanket exclusion of those with criminal records can lead directly to disproportionate exclusion of African Americans and Latinos from the workforce, with an intended impact on their economic security and opportunity, and by the way, the economy as a whole. And this kind of interplay, I think, plays out across a number of different socioeconomic systems in our country, including housing and other areas. As Ed mentioned before, in the area of policing, we are all too familiar with the crisis of policing in this country, with seemingly regular violent incidents between police and members of the community, particularly members of communities of color, law enforcement. Members of communities of color, law enforcement is sworn to serve. So this really illustrates why criminal justice reform needs to be comprehensive. We need to look at sentencing, we need to look at reentry, we need to look at prison conditions. In the past several years, we've had some allies in Congress to sort of take us part of the way. Last year, we had the introduction of many criminal justice reform pieces of legislation. The one that particularly moved was the Sentencing Reform and Corrections Act, which made modest changes to our sentencing structure, did not eliminate mandatory minimums, but reduced them, applied retroactively the Fair Sentencing Act of 2010, which would allow persons who were incarcerated at the time of its passage to benefit from the laws the laws that changed or balanced out the crack cocaine disparity and made that retroactive. It allowed parole opportunities for youth sentenced as adults. It banned solitary confinement for most youth held in federal prison. It permitted earned time credits for those who were incarcerated who participated in prison programs that allowed rehabilitation. Despite bipartisan effort and bipartisan work, that effort fizzled, unfortunately, near the end of the year. The election time rolled in. We had a lot of partisan fighting going on. We also had significant opposition from Senator Sessions and Senator Cotton in the Senate at the time. This year, however, we have another effort being launched by Senator Grassley and others to reignite criminal justice reform. And the prospect for that is obviously very attractive. But at LDF, we think that, as I said before, we need to have comprehensive solutions that go, frankly, beyond sentencing and prison reform, including reforming our policing and law enforcement practices, eliminating barriers to employment, housing, and political and in the political process, to reentry. We need a law reform that requires federal, state, and local law enforcement agencies to collect certain data and engage in anti-bias, de-escalation, and adolescent development training. We also need to make sure that federal funds under Title VI flow only to jurisdictions that have policing practices that do not violate the population's civil and constitutional rights. We also need to make sure, as I discussed before, that the crack powder cocaine disparity is equalized, is removed, eliminated. And we also need to make sure that in the context of criminal justice reform in general, that we stop criminalizing poverty and look to making sure that prohibitively high fines and fees that continue to plague those with criminal records and those who are released from prison are eliminated. More specifically, in the area of specific policies, we're looking at a couple of bills. There is the PRIDE Act, introduced by Senator Booker, that requires law enforcement agencies that receive federal funds to collect and report use of force data and risk losing portion of those funds. In the area of bail reform, we have a bipartisan effort by Senator Harris and Rand Paul to introduce legislation that would offer state and local jurisdictions incentives to eliminate cash bail and put in risk assessment tools in order to decide who should be allowed to be released pre-trial. In the areas of reentry, we have the REDEEM Act, which will allow persons convicted of nonviolent offenses to seal certain criminal records and to seal and expunge certain juvenile records, among other things. We have also bills that were introduced last time, which we hope will be introduced this time, that would allow fair chance hiring. You've heard of Ban the Box, that would eliminate the inquiry into criminal background to some time later in the employment process. Well, there was legislation introduced last year that would apply that to federal contractors, and we're hopeful that will be reintroduced this year. I want to move now to talk a little about what's happening, what kind of threats we're seeing in terms of backlash, what kind of threats and, frankly, obstacles we're encountering in this particular administration of criminal justice reform. As I mentioned before, we're optimistic and hopeful that we'll see affirmative criminal justice reform at the federal level and at the state level. However, at the state and federal level, we are seeing some pushback on creating opportunities for reduced sentences, for prison reform, and for reentry reform. At the same time that folks are introducing bills that I just discussed, we have some introducing policing bills that we consider to be an attack on policing reform itself. LDF has, and others who are joining us, will continue to oppose the types of bills that I'm describing that are sort of called Blue Lives Matter bills or thin blue line bills that increase or enhance penalties for what they perceive to be acts of violence against law enforcement, sometimes overly describing what law enforcement, the definition of law enforcement, or overly defining what law enforcement is, but also doubling down on penalties that already exist, including adding the death penalty. There are also pieces of legislation that would limit liability or civil liabilities for victims of police misconduct. We also have seen in this particular administration, as Ed alluded to, a tough on crime, law and order kind of rhetoric that in some ways is counterproductive to the kind of criminal justice reform I've just been describing. So we have an attorney general who has shown a hostility towards consent decrees, the very tools that we use to hold police accountable, to allow for police and communities to operate in a transparent way, and to allow them to actually make the reforms they need. We also have an attorney general and administration that's rolled back a lot of the initiatives regarding charging that were put forward by Eric Holder and others, Eric Holder and his predecessor, his subsequent attorney generals, that would ease charging against low-level drug offenders. And then finally, we have a situation where the Attorney General has taken one important tool, the Office of Community-Oriented Policing Services, and really reoriented its mission, where at some point, actually in previous history, it would interact with police jurisdictions and local jurisdictions and help them do a better job complying with civil and constitutional rights. Now they've reoriented that mission and really removed this collaborative review process and eliminated that as an option for that office. We have some serious concerns about what this will portend for criminal justice reform in general, both at the state and federal level. But let me end by quickly talking about some strategies to sort of navigate this environment. The first one is to embrace the abnormal. We are not in a normal political environment, not a normal environment either at the executive branch or at the legislative branch of our government. Judicial appointments, executive appointments are critical. And we have folks that need to be held accountable regarding their record on civil rights and criminal justice reform. And LDF and others are trying to do that. We must recognize, I think, that our sort of old strategies and old playbooks that sort of took into account an adherence to the rule of law, for example, and other kinds of norms may have to be refined and may have to be modified in order to meet this new challenge. The other point connected to this is that I think we need to make sure that organizations like LDF and others are prepared, frankly, to become their own private attorney generals to enforce the laws that, frankly, aren't being enforced now by this attorney general. So, for example, in the area of policing reform, we've been very active in Baltimore and actually stood there and helped advocate against the Department of Justice backing away from its enforcement of the consent decree that it agreed to in Baltimore. And the judge, fortunately, agreed with the advocates and agreed with us, and now is frankly forcing DOJ to continue its advocacy. So in situations like that, where DOJ is not going to be sort of moving forward on consent decrees, moving forward on policing reform, I think organizations are going to need to step up and actually be aware and be prepared to step in. And finally, I think there's going to need to be a strategy to pivot to Congress. I think we're pressing Congress more than ever to exercise its oversight role, to oversight its budgetary role, in making sure that they are a check, frankly, to policies that are problematic with regard to civil rights and problematic with regard to the criminal justice reforms that we're talking about today. And this is all the more critical after the Charlottesville tragedy. And I think finally we need to ask some tough questions regarding criminal justice reform. The politics of criminal justice reform, where we had a bipartisan set of actors moving forward, that's happening now. But we need to ask what is all going to be sort of contained in that bipartisan mix. The kinds of reforms I described here today have also been married to regulatory reform that might undermine our consumer and environmental protections, and in fact actually undermine the safety of the very communities we're trying to protect in the criminal justice context. This is all compounded by the fact, as I said before, that we have an administration that does not seem all that open to the kind of criminal justice reform that we have been promoting in the past few years. So I think we need to look very closely at all of this, look very closely at the compromises we're going to be asked to make in the criminal justice reform context, and be aware and be very cautious. Thank you.
Next we have Mr. Garrett.
Thank you, Judge. And thank you to GW Law Review, to Roger and all of you who've so expertly organized this event. I have a PowerPoint slide for my presentation, and it's this one. I wanted to point you to the image of the fingerprint, because I wanted to talk about fingerprints for a few minutes before talking about things that are actually in the essay that I submitted for the symposium, because I think it makes for a useful illustration. Presumably the fingerprint was chosen because it illustrates it's a symbol of catching criminals, using evidence. And I wanted to say a few words about fingerprints. The Challenge of Crime in a Free Society report that we're celebrating or describing the 50-year anniversary of describes the need for more data in criminal justice. It says we need to know much more about crime, and it describes how more data is needed across a lot of different dimensions, but one of them was that we need data on criminals. We need databases. We need to collect information about criminals better. And so one thing that did happen in reaction to that report is there was more federal funding. There are now
large forensic databases in this country, including large fingerprint databases, DNA databanks, different biometric databases too. That was one set of recommendations in the report that were enthusiastically embraced by law enforcement and enthusiastically funded. And even though the report didn't spend a lot of time talking about it, it didn't have to. That was great. We absolutely want to collect more data to systematically and better catch criminals. So fast forward from the Commission report to 2004, when after the Madrid train bombings, a fingerprint is found on a bag of detonators outside of Madrid, and that bag was very clearly linked to the bombing attack. A partial print is found, a latent print is found on the bag, and the FBI, cooperating closely in the investigation, runs a search through the fingerprint data bank that the FBI maintains. They find 20 candidate prints because the computer program itself can't match prints. A human examiner looks at the candidates to see which one might be a possible candidate for a suspect. And they go through those prints, but they also have information about who the 20 people are. And one of them is Brandon Mayfield. And I'm always sympathetic to people named Brandon who suffer injustices. I've never been falsely arrested, but he was. And so he was an Oregon lawyer. And they were like, he's an Oregon lawyer and he's Muslim. And he has represented, at least in one case, Muslims accused of terrorism offenses. He's clearly suspicious. They send his prints to a fingerprint examiner to make the final comparison, having identified him in the data bank. Fingerprint examiner number one says, based on my experience, I see multiple points of comparison here. It is a match. But they were, just to be sure, this is a high-profile case. They send it to FBI examiner number two, and FBI examiner number two says, I agree with examiner number one. I verify that conclusion. This isn't a match. I've identified, multiple points of comparison here. And in fact, I've never not had a match when you have, more than 10 points. And there are absolutely more than 10 points here. But this is a really high-profile case. They send it to FBI examiner number three. And the third examiner, a very experienced fingerprint examiner, just like 1 and 2, says, obviously if you have more than 10 points, it means the fingerprint couldn't belong to anyone else in the world other than your suspect. It absolutely matches Brandon Mayfield. And so he's arrested, spends 2 weeks in jail. The Spanish authorities say, we have a match to someone with known terrorist ties from Northern Africa. What are you doing? Brandon Mayfield had never been to Spain, but his daughter had a map of Spain as part of a high school project on her computer, and they're like, oh, he's thinking about Spain. So there is a match to the actual culprit, and the Spanish authorities point that out to the FBI. They drop the charges. They tried to get Brandon Mayfield to confess. The interrogation was not successful. He gets a $2 million payment for false imprisonment. There's an OIG report which describes the mistakes made in the case. And the FBI does change some of his practices for just cases like this where there's a single fingerprint and there's more of a concern that you would make a mistake than if there are lots of latent fingerprints, including that they want to blind it so that the examiner who's verifying doesn't know the conclusion, because here each of the two follow-on fingerprint examiners knew that the first guy found a match. But this is an example of a situation where, okay, the FBI was listening to the commission report. They collected a massive data bank with fingerprints in it. Of course, it produces candidate prints, which can be a very close match because of the sheer number of prints in the database. But there was no data to support the conclusion that this fingerprint is a match with a person to the exclusion of all others in the world. There have been no studies, there are no statistics on fingerprint comparisons. Statisticians have never been given access to the FBI databases. And 5 years later, there was a National Academy of Sciences report which said there is no statistical basis for conclusions that you can identify forensic evidence to individuals in any field aside from DNA testing. And so you had experts reaching conclusions based on no population data, no statistics. It was a data-free zone in fingerprinting. Now, there's a lot of information on fingerprints. It's very useful for solving crimes. But claims are being made that it was an error-free, it's impossible to make a mistake type of task, and yet errors can be made and were made in this high-profile way in that case and in others. So we have a problem in that you have methods used in policing, not just forensics methods, but methods for identifying suspects, for deciding whether to give someone bail or not, for deciding which neighborhoods to police, which, just like the commission report said 50 years ago, are based on discretion, tried and true methods, common sense and hunch, the commission report said. And they said, we need major demonstration projects, we need interdisciplinary research. Just this fingerprinting example. I mean, there's computerized databases of fingerprints, but statisticians have never brought in to validate the techniques used to reach a conclusion that this print belongs to one person to the exclusion of everyone else in the world. Psychologists had never been brought in until recently to ask, okay, should you be telling the fingerprint examiners that this guy is Muslim and that he's our prime suspect and that the 2 other fingerprint examiners already found a match? Is that relevant to the task of looking at the little points in this fingerprint image? It's not, and there's predictable cognitive bias if you introduce that information into the process. And so you see this problem of the selective reliance on data, and in an era of big data, data is being used, but data is often used to solve certain problems and not others. And so the challenge for us today is that in an era where evidence is informing more aspects of our lives and data is being used in more aspects of our lives and technology is changing our lives, will policing, will criminal justice remain, like Michael Tonry famously called it, an evidence-free zone? So, the recommendations of the commission were not followed. We do not have a National Institute for Criminal Justice Research. We have grant making through NIJ and BJS and some other entities, and nonprofits have stepped in to fund much, much more criminal justice research than in the past. But if you look at some of the examples where more research has been done and where more evidence has been collected, it's been, as the speakers have already been describing, only slowly made its way into change in actual criminal justice practices. So just like in the area of forensics, where we have large forensic databases, but no research on whether those techniques actually have any foundation for use in the courts, there's been a large effort to push evidence-based methods to reduce mass incarceration. These Justice Reinvestment Acts and initiatives around the country, more than 30 states have passed them. But when those JRI initiatives have been evaluated by Pew and others, they found that they've sort of slowed down incarceration in major states, including red states that had not had an interest in reducing incarceration before, states like Texas, like Mississippi. But the only states actually that have substantially reduced incarceration, California, New Jersey, New York, have been states where there was major litigation. You have, in the area of policing, much more reliance on big data and prediction. And you've had since the 90s the use of things like CompStat in New York to do predictive policing. But where has data been used to try to evaluate the police, to look at patterns of potential racial bias? Often that's happened, like in New York, because of litigation. Because lawyers came in and said, well, what's the data on race and stop and frisk? Unfortunately, many police departments do not want to collect that data themselves voluntarily. They want to collect data on criminality to target their resources, but not data that may be critical of their own policing patterns. In the area of risk-based sentencing, there's been a big move to use evidence-informed approaches in sentencing, and not just the common sense and hunches of judges, just like the common sense and hunches of experienced fingerprint examiners, but there's a real mixed track record of courts turning away from common sense and hunch and relying on instruments. There's the concern that instruments are used with data that's not transparent, not subject to outside research or statistical validation, sometimes by proprietary companies. But there's also the concern that in many jurisdictions where it's within the discretion of a judge whether to use the instrument, whether the judges use it at all, or whether they use it to provide more lenient outcomes to the people that they would have given more lenient outcomes absent the instrument. And so some of the initial studies are coming in suggesting that when judges are using either a pretrial or a sentencing risk instrument, that they often disregard the instrument entirely and rely on their own priors. So there are these larger questions about whether evidence actually informs criminal justice actors or whether it's used in a self-interested way that doesn't necessarily improve outcomes. In this conference, we've mostly heard from people like me, lawyers, and also policymakers, not from statisticians, psychologists, the type of people who we also need to bring in to study the use of evidence in criminal justice. There's a lot of talk now about doing more evidence-based or informed work, and hopefully the next 50 years won't be like the last 50 years, but I think that the challenges still remain that evidence tends to get used to the benefit of local or even state and national actors that want to use data only selectively and without outside review, scientific research, study, concern with error rates, concern with using data to actually police the police and evaluate what's being done. So we may be on the cusp of a real movement towards more evidence-informed criminal justice, but like the technology that's affecting our lives in so many ways, I think there are deep questions about whether things will actually improve when we have more information about them. Thanks so much.
Next up, we have Mr. Marcus.
Well, thank you, everyone, for having me here today. This is a very important occasion as we look again at the 1967 President's Commission and ask some significant questions. But I suggest to you that there is no question which is more important in terms of achieving justice than to ask whether the Sixth Amendment right to counsel is being enforced and applied properly. More than a decade ago, my colleague, Professor Mary Sue Backus of the University of Oklahoma faculty, who sends her regrets she could not be here today, we spent more than 3 years looking at this question, and our answer then was sobering and deeply troubling. Today we look again, and the answer is yet again very disturbing. Let me begin with some words that many judges, Her Honor excluded here today, many judges across the country seem to have forgotten. In our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us to be an obvious truth. Governments, both state and federal, quite properly spend vast sums of money to establish machinery to try defendants accused of crime. Lawyers to prosecute are everywhere deemed essential to protect the public's interest in an orderly society. Similarly, there are few defendants charged with crime, few indeed, who fail to hire the best lawyers they can to present and prepare their defenses. Every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. That, of course, is from Gideon versus Wainwright, now more than a half a century ago, just a few years before the report. We all say that Justice Black was correct in writing those words, yet in practice, it is as if in many parts of this country, we do not really believe those words. That is what we found 10 years ago. That is what we find today. What we see now is excessive public defender caseloads, insufficient compensation for appointed and contract defense lawyers, limited access to attorneys, lack of resources critical to competent representation, and the resulting ineffective assistance of counsel. These can all be traced to inadequate funding across the country. In our article, we cite a number of cases which reflect these problems and directly affect the ability of our criminal justice system to do justice. When we first did our research here, we identified several approaches to improving the right to counsel situation. The first was involvement of the federal government. Positives here: very public statements in support of improving counsel programs by Attorneys General Holder and Lynch. Haven't heard a word yet from Attorney General Sessions on this, though he's spoken on many other issues. Also very positive has been the DOJ involvement in specific pieces of state litigation. More on that in a few moments. Now, another approach was the movement then for increased state funding and oversight of public defense operations. We were actually pretty enthusiastic about that and optimistic 10 years ago. But you'll recall 10 years ago was 2007. And when the recession hit, it ground these reforms to a halt. And the reality today is that the funding problem in many states across the country is even worse today than it was 10 years ago. And the examples are pretty dire. Let me share some with you. In fiscal year 2012, Nashville, Tennessee public defenders handling misdemeanors took up to 1,000 cases each year. 1,000. Typically giving them less than an hour to spend on each case. In New Mexico, where the number of felony cases has almost doubled since 2011, the number of public defenders has been cut by a third. In the years before a class action lawsuit successfully challenged the practice in the state of Washington, 2 part-time appointed lawyers representing indigent misdemeanor defendants handled over 1,000 cases each year. As a result, and there's an extensive study on this, the lawyers spent less than an hour on each case. They engaged in little to no investigation. They only communicated with their clients for a few moments in an open courtroom. They based their pleas of guilty entirely on the presumption that the police report was accurate. In 2014, one Marion County, Indiana, it's Indianapolis, one lawyer handled over 1,300 cases in a single 12-month period. A 2010 report determined that in Idaho Falls, a single attorney was assigned to handle more than 4 full-time attorneys' worth of work, a caseload that allowed, on average, 1 hour and 10 minutes per client. Back then, we talked about other approaches that might help, looking especially to what the courts could do. Well, the first of these was to encourage systemic litigation, to move legislators, really to force legislators, to address the deficiencies of the indigent defense systems. Now, it's still quite early in the process here. Litigation takes a long time. And while there have been some missteps, actually litigation is pretty encouraging so far. In a couple of states, Idaho and Pennsylvania, the litigation is moving forward pretty well with the strong assistance of the U.S. Department of Justice. These are class action lawsuits which identify system-wide issues. Now, the big success here is New York. The state of New York, it's really quite remarkable. The planets kind of aligned here. First, we had the Judith K. Commission, which reported on what they called the crisis in the delivery of defense services to the indigent. And then the State Court of Appeals in New York, that's the highest court. The State Court of Appeals found that an action challenging this system could in fact go forward. The case was settled, and now in the coming 2018 budget, statewide, there will be major changes, such as providing counsel at arraignments, establishing workload limits, implementing standards, ensuring effective supervision and training, and giving access to resources such as investigators and experts. The second here, and I must say this was close to my heart, was the hope that Sixth Amendment challenges in specific cases, not system-wide, but specific cases based upon excessive workloads of counsel and insufficient preparation time would resonate with courts across the nation and would result in the U.S. Supreme Court becoming more involved in assuring that constitutional guarantees were being met. Oh, naive me. That was not to be the case. In these actions, appeals lawyers consistently raised the question of ineffective assistance of counsel because of these broad problems and consistently lost. With relatively few exceptions, really the death penalty cases, the courts, and especially the U.S. Supreme Court, they have turned a blind eye to ineffective assistance concerns. Instead, the reliance here is on a famous U.S. Supreme Court decision called Strickland versus Washington. There, the court found that effective assistance of counsel was the linchpin of the Sixth Amendment. Hooray. However, ineffective assistance of counsel under that decision is exceedingly difficult to show. To prevail, for those of you who have not read the case, to prevail on an ineffective assistance of counsel claim, one must show that the lawyer at trial, and it's usually at trial, could apply to plea bargaining for those of you who are familiar with the Padilla line of cases. You must show that the lawyer was not reasonably competent, giving great deference to judgments of the lawyer. Indeed, language in some decisions across the country make that just about impossible to show. Here is what one U.S. district judge wrote recently. But the Constitution does not guarantee that a defendant will have a perfect lawyer. It does not guarantee that he will have a good lawyer. It does not even guarantee that he will not have a really bad one. The Supreme Court has gone out of its way to make clear that in order to obtain a new trial on ineffective assistance grounds, the petitioners must do more than show that he had a bad lawyer, even a really bad one. That's really quite striking language from a federal district judge. But even if you could show that this terrible lawyer, I assume you have to get to that level, if you could show that this terrible lawyer represented the defendant, that's not ineffective assistance of counsel unless the defendant can show, and the burden is on the defendant, not on the government, unless the defendant can show that the lawyer's performance affected the outcome of the trial. Now that may work in the rare case of the intoxicated lawyer who comes in absolutely stoned, or the one who didn't look up the current version of the law as to expenses for experts, an actual case recently, a death penalty case. But it clearly does not work when the lawyer just did not have enough time to adequately research the law or have the resources to track down and interview possible witnesses. It's just about impossible. How does one prove the negative? Well, there are some straightforward fixes that would help. They would help a lot. Changes that could make a real difference. For instance, the Supreme Court could say, as it does with standard Gideon violations under the Sixth Amendment, that if the lawyer's performance was not satisfactory, that should be automatic reversible error, nothing more. And if the judges are not willing to go that far, and quite clearly they are not, if a burden must be satisfied as to effective work of a lawyer, that burden should be on the government to demonstrate that the incompetent lawyer did not contribute to the outcome at trial or elsewhere. Also an impossible burden. Or the Supreme Court could take a really dramatic step and truly act on the words that is written many times. It once said, of all the rights that an accused person has, the right to be represented by counsel is by far the most pervasive, for it affects his ability to assert any other rights he may have. As a few, but sadly only a very few, state courts have found, if the traditional markers of representation are absent, meaningful client-attorney contact, investigation, advocacy, and advocacy, if those disappear with heavy caseloads and lack of funding, that should be viewed as a denial of counsel. In short, counsel in name only is a violation of Gideon. It's a violation of the Sixth Amendment, even without provable prejudice in a given case. And the United States Supreme Court should so state, though again, I see little inclination on the part of our justices to do just that. Now, I've painted here a pretty gloomy picture of where we are in our criminal justice system in terms of providing a lawyer to fulfill the hope of Gideon versus Wainwright and the direction of our founders in the Sixth Amendment. Sadly, it is a fact that all too often today, we simply are not doing ourselves proud in terms of making sure that justice is served with poor people who are accused of serious crimes. Thank you very much.
Okay. May it please the court, counsel, members of the jury. Judge, I really miss those days. But anyway, I really want to thank my alma mater, GW Law School, for inviting me here this afternoon. As a staff attorney for the National Prison Project during the mid-1980s, I often cited in my conditions of confinement briefs the 1957 case of Trop versus Dulles, which quoted Supreme Court Justice Warren's statement, which stressed the importance of considering, and the quote is, the evolving standards of justice that mark the progress of a maturing society. I'm gonna repeat that. The evolving standards of justice that mark the progress of a maturing society. And as we move forward, I've often wondered, have we evolved? During the height of the war on drugs, unnecessarily lengthy sentences were robotically meted out with seemingly callous abandon. Shocking punishments over the past 30 years of 10, 20, 30 years and life imprisonment for drug offenses were commonplace. Such punishments should have offended our society's standard of decency, but they did not, and they have not. So, lengthy sentences for drug offenses are cruel, but they are usual. And they became usual with the advent of the 1984 Comprehensive Crime Control and Safe Streets Act, which eliminated parole in the federal system. 2 years later, the 1986 Anti-Drug Abuse Act established mandatory minimum sentencing schemes, as well as the infamous 100-to-1 quantity ratio between crack and powder cocaine. And then 2 years after that, the 1988 Act added conspiracy. The combination of all of these acts were responsible for flooding the federal system with people convicted of low-level nonviolent drug offenses, all of which have had a disproportionate impact on people of color. As a precise result of law enforcement's decision to deploy its officers to the Black community, targeting young Tyrone standing on the corner and make 200 arrests. And Amani, the police and the prosecutors and the politicians, they rationalized that decision then and today by saying that they're responding to Miss Pearl, the elderly lady who lives on the corner. And the police say they came to and they come to Black communities in full militarized gear because Miss Pearl calls them, and that is what she expects. They say that she wants them to immediately make those 200 arrests in her community, that she don't want to hear about any 2-month investigation, Tracy. But I submit that Ms. Pearl does not understand just what a mandatory minimum sentence is. That it doesn't matter if college student Kimber Smith gets caught up with the wrong guy and he beat her and threatened her family so bad that she was scared to come forward about his drug dealing. It doesn't matter that she's pregnant when thrown in prison. It doesn't matter that she never used or handled any drugs. The mandatory minimum drug law said that she had to serve time, 24 and a half years, students, of it. There are no mitigating or extenuating circumstances when it comes to mandatory minimum sentences. Ms. Pearl didn't understand what the crack versus powder 100-to-1 quantity ratio meant, that those convicted of selling 5 grams of crack cocaine received a mandatory prison term of 5 years, whereas it took 500 grams of powder cocaine to receive that same 5-year sentence. She didn't know that 1/3 of all federal cocaine cases involved an average weight of just 52 grams of weight of an ordinary candy bar. She didn't understand the young Tyrone was not a major drug kingpin and that there was a prison bed waiting for him based on the test scores that he made from when he was in the 3rd grade. And Todd, Ms. Pearl never even stopped to think of the adverse impact on political empowerment in the Black community as a result of 250,000 African-American men being stripped of the right to vote as a result of their felony conviction. She was ignorant of the termination of parental rights under the Adoption and Safe Families Act of 1997, the loss of school loans under the 1998 amendments to the Higher Education Act. She didn't know that her grandson could have her kicked out of public housing as a result of his drug conviction, that her daughter could be denied public assistance, or her son unable to find employment because of the infamous box, "Have you ever been convicted of a crime?" Indeed, it never dawned upon her that a young Black woman could be sent to Harvard, Judge Jackson, for the cost of what society pays for her incarceration. During the early 1990s, I remember walking the halls of Congress, and I'm not doing this, I'm just waiting for my water. Okay, during 1990, I remember walking the halls of Congress, lobbying against the various crime bills, which culminated in the Violent Crime Control and Safe Streets Act of 1994. This bill featured the largest expansion of the federal death penalty in modern times, the trying of 13-year-olds as adults, the gutting of Pell educational grants for prisoners, the implementation of the federal 3 strikes law, the refusal to address the crack powder disparity, and monetary assistance of money for states to lock up more and more people for longer periods of time in exchange for loads of money to build more prisons. And I characterize that 1994 crime bill as the granddaddy of all the crime bills. And Charlie Sullivan, you know, because you were around at the time, it was an anti-prisoner bill. It was an anti-youth bill, a bill which had a discriminatory impact on the African-American community. And I would say that conditioning the money to states that adopted truth in sentencing laws had the most far-reaching impact because it spurred an astronomical rise in prison construction across the country and, along with mandatory minimum sentences, lengthened the amount of time people would serve, solidifying the prison industrial complex and creating a mindset for imprisonment as the default punishment as opposed to consideration of alternatives to incarceration. The bill put 100,000 new cops on the streets, Tracy, and while this is often lauded as a positive development, more cops on the street also coincided with the ascendancy of the issue of racial profiling, which before the 1994 crime bill was not even a term that was part of the popular nomenclature. And there were many other provisions within that crime bill that advocates today, both progressive and conservatives, are seeking to undo. The Omnibus Violent Crime Control and Law Enforcement Act of 1994 indeed was a nightmare come true. And although touted as tough and smart, it was actually draconian and poorly conceived, filled with ineffective provisions that not only contained serious flaws, but invested scarce resources in more prisons and longer sentences without a concomitant reduction in crime or increase in public safety. The prevailing narrative at the time was tough on crime. Ted, you know that because you wrote about that way back then. A narrative which caused then-candidate Bill Clinton to leave his presidential campaign trail to oversee the execution of a mentally challenged man in Arkansas. The same narrative that popularized the myth of the child super predator. And 20 years later, we were in the midst of the dawning of a new narrative, one that was truly smart on crime. This new narrative resulted in the 2008 passage of the Second Chance Reentry legislation. It resulted in the Fair Sentencing Act of 2010 becoming law, which reduced the 100-to-1 ratio between crack and powder cocaine. It was exhilarating to not only witness, but help to achieve, along with my colleagues such as Charlie Sullivan, to help to achieve Todd, Cox, Ed, Chung, these winds of change. The narrative on criminal justice was indeed shifting, and justice system reform was not the lightning rod it once was decades ago. I was delighted, Ed, when former Attorney General Eric Holder announced his smart on crime policies, which focused federal prosecutions on large-scale traffickers as opposed to bit players. I said right on when President Obama became the first sitting president to visit a federal prison. I applauded his executive clemency initiative to provide relief to those serving inordinately lengthy mandatory minimum sentences, and I was thrilled with the bipartisan Senate introduction of comprehensive federal criminal justice legislation that appeared to have a very real chance of passage, the Sentencing Reform and Corrections Act. All of these reforms would have been unthinkable even a few years earlier. Some would not even have passed the laugh test for serious criminal justice reform. It was indeed a new day and a new narrative being formed. A year and a half ago, maybe it was 2 years, I don't remember, I sat in the Senate Judiciary Committee's hearing room witnessing the marking up of the Sentencing Reform and Corrections Act. Now, granted, this was not the bill that Nkechi Taifa would have written, but I supported it. I tweeted that it had a magical Goldilocks type of allure, not too hard on crime, not too soft, but just right to pass in this Congress, meaning last Congress, at that time. It was a carefully negotiated bipartisan compromise bill that sought to reduce some mandatory minimums, broadened the safety valve, made the Fair Sentencing Act and other provisions retroactive, expanded compassionate release, allowed for juvenile sealing and expungement, juvenile parole, and the limiting of juvenile solitary confinement. But all that was yesterday. A change in administration occurred, and the bill's future in its current state is quite uncertain. Today, Attorney General Sessions has dusted off policies from the past that directed prosecutors to charge arrestees with the most serious provable offense and resurrected such policies to obliterate the smart on crime sentencing policies that were beginning to manifest. Attorney General Sessions' new DOJ charging and sentencing policy will not only reboost the destructive war on drugs, but also exacerbate racial disparities, soar the prison population, and increase costs to you and I as taxpayers. We must not allow this to happen. Congress must pass measures such as the Reverse Mass Incarceration Act, which is critical to incentivizing evidence-based decarceration programs that reduce crime and enhance public safety. Congress must eliminate mandatory minimums. Alma, I know that your boss spoke earlier today. Bobby Scott always stalwart for maintaining the principal stance of the abolition of mandatory minimums. We must change the federal drug conspiracy laws. Congress must create a second look mechanism by which lengthy sentences can be systematically reviewed as recommended by the bipartisan Colson Task Force. The Federal Bureau of Prisons must strengthen compassionate releases capacity to safely decrease the federal prison population. And the administration must consistently grant clemencies to deserving candidates, not people like a pile. Anyway, conclusion. Although we have journeyed from tough on crime during the 80s and 90s to a brief stint in smart on crime during the last term of the Obama administration, we seem to be slipping back to being dumb on crime during this current administration. However, Dean Fairfax, we are now at a point where we can openly discuss the data that we have known for years that sending people to prison and keeping them there for unconscionably lengthy periods of time does not make us safer, does not deter future crimes, does not promote successful reintegration back into our communities. With bipartisan alliances bringing together unlikely partners such as the Koch brothers and the ACLU, there is cover now to find better and more creative and more cost-effective ways to push the envelope to achieve change. Regardless, as I'm concluding, of whether we are motivated by fiscal, religious, big government, or racial concerns, we need to join together and raise the ante and have the audacity to advance creative solutions. The Miss Pearls of our community are crying out for all of us to take our place in continuing the struggle to bring smartness to criminal justice reform so that we can, in the words of Chief Justice Earl Warren, actualize the evolving standards of decency that mark the progress of a maturing society. Thank you.
Thank you all for your presentations. We do have a few minutes for questions, and I might start by trying to tie together the themes of some of the presentations that we've heard. Ms. Taifa talked about the war on drugs and whether we are now returning to the policies of the past, but if you've been watching the news lately, you will recognize that the president yesterday announced a public health crisis in the context of the opioid epidemic, and I wonder whether that suggests perhaps a ray of hope with respect to policies, thought processes, the treatment of addicts and the like. Are we really moving into a reversal with respect to the considerations of drugs in our society or not? Does anybody want to respond to that sort of general question?
I can start. I think that, it's laudable that I think that's getting the attention it deserves, but that conversation started last year when we were talking about comprehensive criminal justice reform in the context of its impact on African Americans. And we saw in that debate a contrast with how African Americans were treated during the crack cocaine epidemic and how, frankly, others were treated during the opioid epidemic. And I have to say it fell along racial lines. So I'm optimistic about what the announcement portended yesterday. I would hope that the same largesse and treatment of folks in the other camp, so to speak, who are suffering from effects of the many years of the war on drugs, I hope that largesse passes on to those communities as well, and that the policies that are being sort of developed along health and sort of social service treatments apply to those communities as well. And that's what we hoped, I think, last year. It's what we hope this year. And we just want there to be equitable treatment.
I just want to say ditto. I agree 100%. There needs to be a sea change in terms of what we're talking about in terms of enforcement. We're going to take a public health approach, and we're going to maintain the law enforcement approach. I'm hopeful that all of the different systems that Ed Chung was talking about work together to make sure that it is a health approach. But on the other side, I also hope that all those who have been languishing in prison in years as a result of the tables being turned the other way have the opportunity to get out from under the imprisonment that they are in as a result of those policies back then.
Thank you. Mr. Chung, I found your proposal that we think about the policing end of this to be very intriguing, and I'm wondering to what extent do you think that this is likely, especially in the current environment in which police are under some scrutiny? Do you think that it's possible to really encourage people to become police officers, and is that really the best way to affect change?
Well, second question first. I'm not sure if it's the exact best way. I think I will say this though, not to minimize the question there. I think it has the possibility, but I didn't choose that to be the quickest or the easiest. But whenever we talk about criminal justice reform, the other side, and it's not an other side political or whatever, but the ideological other side always talks about police officers and officer safety. And it's one thing to have police chiefs stand up and talk about what it means because they're in charge of an entire organization. But coming from the Department of Justice, when we got a line officer to be able to talk about criminal justice reform or reforming public safety, the weight that carried was far greater than what a chief could talk about because they're talking about what they experience every single day. And so and this goes beyond the things that we've been talking about in recent past, even from the 21st Century Policing Task Force about guardian versus warrior. And I fully embrace guardian over the warrior concept. But in addition to that, when you have somebody who is thinking about their profession of policing in a way that is much more holistic and rooted and sees themselves in where they are in the system and the change that they can affect, I think it has the potential to make great change. Obviously, it's a concept, and there's a lot of work that can go behind it. But in a time where you have policing shortages, and Nkechi, we're not talking about the size, we're just talking about openings in police departments and whether or not all of them should be filled, that's a different question. But in a time where there are jobs that are to be had, and when there are times when young people are looking for meaningful jobs, I think it's something that definitely should be explored.
Let me ask Mr. Garrett, sort of shifting gears, we have different strands of criminal justice issues. I didn't know whether or not to be heartened by your remarks or depressed, because it seemed to me that you were suggesting that the evidence-based, database reforms, which people have tended to believe are helpful and hopeful insofar as they take us away from subjective views of culpability and people's length of punishment, et cetera, were not really the real solution because people were misusing the data or we're not analyzing it properly. So are you suggesting that we ditch it or that we fix it? And if so, how?
That's a great question, and yes, it's better to have information about what is happening in the criminal justice system and how that information is being used than to not have any, and to just say we're just going to trust the common sense of whoever it is. But the concern is that only if selective data is being collected and not on important topics that we need to understand better, or if it's not being evaluated by anyone with training, then you could replicate problems or maybe make them worse, actually. And so unfortunately, we don't have the kind of independent institutions in most places that are actually, it's their job to collect and analyze criminal justice data. Sometimes you have selective institutions, certain sensing commissions that are looking at certain types of data, but not others. You have police agencies that are increasingly hiring data analysts to work within police departments, which is interesting and exciting, but there's not a lot of it. You don't have the kind of systematic reviews because there are just not enough studies done to study anything systematically. And so, for example, in the eyewitness evidence area, there are thousands of studies. I'm working on a project where we're doing a systematic review. It's going to take forever. It's a gigantic systematic review like you have in medicine, looking across lots of different studies that are conducted the same way, and you can learn something about which factors really impact a medical treatment or an eyewitness's memory versus others. But they're like, there's something called the Campbell collaboration, which uses systemic reviews methods and systematic reviews in criminal justice, and there are like a couple dozen of them. And a lot of them really wouldn't fit the criteria of what counts as a systematic review. And so then when you have a new problem and we need some data, what do? There's this study that just came out in DC. In DC, it's laudable. They have this DC lab to study data in DC government. They did a study of the use of body cams. They randomized it. Sounds like the design was pretty good. And then the criticism when it comes out, and they say, we don't really find a strong effect of the use of body cams on police citizen interactions or use of force. Criticism is, well, that's just one study in one police department. We need systematic data from other places. DC, there's been a lot of talk about the need to improve citizen-police interactions over years. Maybe the police officers were already sort of reacting to training that they were getting, and so the cameras didn't make a difference here or there because of other things in their training that had changed in the last few years. That's just one place, or a small department says, but we're a small department. We have very different interactions with citizens than they do in a city like DC. And so even when you do have some evidence, people either take a study the wrong way or they correctly observe that study might not be representative. So there are just huge, huge problems with the inadequacy of research in criminal justice. And then you have these situations when there's really pretty good data and it gets totally ignored by the relevant actors because they don't like it or don't feel like using it. So I don't know. I'm not optimistic or pessimistic, but we'll all have lots of interesting work to do.
Yes.
Hi, Brandon. I have a question for Brandon Garrett. Okay, so I really enjoyed your story about the other Brandon as your opening, and I can't decide what to be afraid or what to be most concerned about in the story, right? Is it that the FBI was using the fingerprinting and that's inaccurate? Or is it that the FBI went into the database to try and predict who it was without any other kind of information, and perhaps to the exclusion? So basically that they were trying to predict to the exclusion of any of their other kind of problem-solving, I guess, techniques. I don't know. So what do you think? I mean, you scared me. I mean, it was like a scary story, but I just would love to hear more. Well,
particularly scary because it's like, wow, they had fingerprint evidence verified by 3 scientists, right? Yeah. And they never make mistakes. But they did investigate, right? They investigated and they found out that this guy is a Muslim and clearly has represented some suspected terrorists. This is exactly the kind of person who fits the profile, we think, the psychological profile of a terrorist bomber. Unfortunately, he'd never actually, been to Spain or engaged in terrorist activities. I like that example because we think of fingerprinting as the symbol for reliable use of both scientific evidence in criminal cases. We have these big databases. People figure that that's great. We should have databases. It's more reliable maybe than just asking around to see if anyone knows something. This was an example of a scientific investigation gone incredibly wrong. But it's also an example of relying on common sense and hunches because there's a seeming use of data and databases, but really the area of fingerprinting has relied on, the technique involves the experience of a trained examiner. Right? There's no database or scientific method to describe what a fingerprint examiner does. They look at 2 prints and they look at them and they see things that look like they're the same, and based on their experience they conclude it's a match. So it's a subjective black box judgment. And how good is someone at forming those judgments? Does experience doing it over the years just sort of destroy your eyesight and make you worse at it? Or actually do you hone your skills at identifying little things in fingerprints and become better at it? Or do judges become better at sentencing after experiencing lots of cases? Or do they develop more and more tunnel vision and they rubber stamp whatever the plea deal is? In lots of areas, we need to know, like, are professionals good at exercising their judgment? As lawyers, we don't like our judgment questioned. We don't like to be told, look, really what a reasonably effective lawyer would do is, like, hire a social worker because you're not any good at talking to foster parents and psychiatrists. And so, there's fields have been transformed by questioning of professional expertise, and there's, an evidence-based revolution in medicine. It's not easy for doctors to be told that their traditional prescription habits aren't great. But that's I think what we need to go through.
Well,
And to some extent what's happening.
It sounds like we still have reasons to be afraid, and we certainly have appreciated all of the presentations from today. It's a lot to think about, but please join me in thanking our panelists.